Good afternoon, and welcome to what I believe will be our final meeting of the Housing and Consumer Protection Subcommittee of the General Laws Committee in the House. We've got 3 bills on our docket today. We've got 2 senators that are here so far. I see Senator Marsden is here first, so we'll let Senator Marsden go first, and then we'll take up Senator Evans' bill. Senator Marsden, you have a substitute, is that right?
I do, sir, and would ask that be...
Amendment, I'm sorry, it's an amendment.
Call roll.
We got a quorum present. I think we're good. It's getting late. It's the last meeting.
Yeah, right.
All right. So has there been a motion on the amendment? Is there a second? All right. As many as favor that motion will say aye.
Aye.
Opposed? All right. The amendment's before us. Clerk, can you tell us, or Madam Counsel, can you tell us what the amendment does real quick?
Yes, Mr. Chairman. So on line 230, after label, we're going to strike the remainder of line 230 and through the word listed on line 231 and insert that does not meet the requirements of 21 CFR Part 101. And then we make that same amendment again on line 454 and 455.
All right. And as I understand that, Senator Marsden, that sort of gives peace in the valley as far as this bill is concerned. Is that your understanding as well?
Yes, sir. It's a technical amendment that just the substitute cites the FDA's definitions and requirements for food labels, 21 CFR Part 101, which I'm sure you all have memorized, but it brings it into alignment with the FDA.
Right. And so the concern I heard from some of the folks that do labeling is they didn't want to have a separate set of standards for the state and for the feds and be in violation of one, possibly not in compliance with the other. And this kind of cleans all that up, so they don't have to have that same concern.
It does, and it just makes this actionable under the Virginia Consumer Protection Act within 20% of what they say is supposed to be in there, either high or low, that you can cover. We don't hold you to a perfect standard on nutrients, but it just allows and puts people on notice that if you say something's in a product, it needs to be there.
Gotcha. Anyone in the audience wishing to speak in favor of the bill?
Mr. Chairman, Brad Copenhaver representing the Virginia Beverage Association. I want to thank Senator Marsden and his staff for working with us. We had expressed some concerns about the different standards, worked with some of our folks to get this language, and so we really appreciate it. We don't have any concerns with this bill. The biggest concern with us was 2 different standards, and so this brings us into line with federal FDA rules, and we're very happy with that, so we appreciate it, and thanks, Senator Marsden.
Right. Anyone wishing to speak in opposition to the bill? Seeing none?
Report.
It's been moved and seconded that the bill report. Clerk will open the roll. Members will cast their votes. With amendment. The clerk will close the roll. Senator Marsden, your bill report 6-0.
Well, thank you very much. I want to come back. You guys are nicer to me than they are over in the Senate.
But we always appreciate folks that are looking for consensus, and consensus builders, they're looked favorably upon. Senator Eben.
Thank you. Thank you, Mr. Chair. Speaking of consensus, SB 1357 is a consensus recommendation of the Ethics Council in modifying the Conflicts Act. It basically, right now, if you have a transaction involving your or a vote involving your spouse being considered for a paying position, that would be a conflict. But if it's a volunteer position, that's not clear. And after discussion, it was our decision that we wanted to ask you to modify that statute just to make it clear that it is a conflict when you vote on matters concerning your spouse.
All right.
And the language is, not a lot of language, but it's on lines 117 and 118. And Mr. Petto from the executive director of the Conflict of Interest Ethics and Ethics Advisory Council is here if there are technical questions.
Yeah, I have some technical questions. So, Mr. Petto and Senator, thank you. So, as I understand this, I think from the Senator's explanation, this bill comes from a situation that's the situation described, I guess here's my struggle. The situation described by the Senator doesn't seem apparent from the words in the bill. And I think I'm sure there are very good legal reasons for that, right? But I don't see anything about appointments. I don't see anything about voting for your spouse when there's an appointment or not. I see language about transactions. I see language about the subject of a transaction. But if I'm, correct me if I'm wrong, but the history of this is that there have been, and we talked about this on the phone, so I'm not surprising anybody, but you've been asked for advisory opinions, informal advisory opinions in the past, maybe 3 to 5 times over the last 8 to 10 years. You can correct me on the numbers, where somebody in a locality or some appointing authority would like to appoint their spouse to a board or a commission or some role non-paying, and they've asked for that advice, and you've been able to give them the advice that if they want to do that, that's okay. Is that accurate?
Mr. Chairman, members of the committee, Stuart Petto, Chairman of the Ethics Council. Yes, Mr. Chairman, you're exactly correct. That is the situation that's happened a few times where someone wanted to appoint their spouse to a board. It was a volunteer board. There would be no financial benefit, direct or indirect. As long as you can be fair and objective, you are permitted to do it under current law. The Ethics Council's position was you should never be voting or nominating your spouse at all. You just can't be objective.
All right, I just want to clear up for folks too, because there's counsel with an E, which is you're an attorney, and then there's the Ethics Council, which is a body of people that is made up of legislators and mostly legislators. Is that right?
Yes, and gubernatorial appointees.
Gubernatorial appointees, right. And so and this came to the Ethics Council's attention because you were asked for a formal written opinion by somebody. So in other words, you've sort of been able to get away with the informal advice, saying, yeah, it's allowed, but do you think it's a good idea? But now somebody's like, no, I want it in writing from you that I'm allowed to do this. And so that required you to take it to the full council. Is that right?
That is correct, Mr. Chairman.
Okay. And so what the prohibited, the conduct, the specific conduct that is troublesome to the council is, again, appointing your spouse to any commission, regardless of the reason. But the language we have in the bill is, again, it doesn't, like as Urban said, it's not a lot of language. So why do we have to do it this way, I guess? Why can't we have language that says you can't appoint your spouse to a commission? Why does it have to be done this way? Because what I worry about is that using this very generic language, we might capture more situations than what the council was concerned with.
That's a very good question, Mr. Chairman. And actually, we did it this way in order to make sure that we did not capture conduct that would not otherwise currently be allowed. We sort of have to take for COIA analysis things in like step 1, step 2, step 3. There are situations currently under the law where you can be involved with a transaction involving your spouse, even if it does involve some kind of financial benefit, if you meet one of the other exceptions that are provided for in for the state and local 2.23112. So we did not want to change that. There's times where it's perfectly permissible. And there would also be times where it'd be perfectly permissible for you to appoint, or not make a point, but vote on your spouse if it was in a block of 3 or more. So we did not want to change that. So we took the most narrow focus we could, which is saying you inherently, if it involves your spouse, you inherently have a personal interest in that transaction, period. Doesn't matter whether there's money or not. And then at that point, if one of the existing exceptions applies in the law, you could proceed with that transaction. If not, you can't.
Right, but again, this doesn't limit, it's not limited to appointments, right? This says the subject of any transaction. Is that right?
That is correct, yeah.
Okay.
So.
All right, are there any questions from members of the subcommittee beyond what I've sort of gotten into? Any questions? Is there anyone in the public wishing to speak in favor of the bill? Come forward. All right, anyone in opposition to the bill? All right, so seeing none, Senator, I got 2 issues, I guess, 2 problems that I've got, unfortunately. One is, I was watching Senate Finance yesterday, and this issue came up a lot, which is that we treated the bill, we had a bill that very similar to this, actually identical to this, that was brought forward by Delegate Watts, which did not advance out of the House. So if we were to advance this bill, we'd be treating your bill differently than we treated Delegate Watts's bill. And the other concern that I've got is that I understand sort of what we're trying to do here. I don't think the words kind of match the intent, and I'm just uncomfortable at this point that this is the best way to try and address the very narrow problem that you've got with appointments. And then I guess the third question I've got is whether why we don't leave it to the voters to be upset. So if somebody, an elected official, appoints their spouse to a commission, I mean, the remedy for that seems to be you don't vote for them the next time because you think they're appointing, they're keeping things too close. They're exercising nepotism. So What I'd like to do is spend a little more time thinking about this problem and going over it. It's just like we wanted to do with Delegate Watts' bill, spend some more time thinking about whether this is the best solution to that problem or not. So I would entertain a motion if it's possible, and then you can certainly get the last word, but I think probably we'd want to take this by so that we can have some more time to think about it. But Senator Evans.
Yeah, I just wanted to, if you watched all of Senate Finance yesterday, you saw that there was one bill that we did not, identical bill that we did not pass from the Senate, that we passed the House version yesterday. And I believe the words that Senator Deeds used were that he had an epiphany, or that we had an epiphany. So if you don't like the policy, I understand. But I wasn't here for your discussion of Delegate Watts' bill. I heard it wasn't docketed, so I don't know if you discussed it and had the same issues with it. The words are the same. So if you already discussed her bill and took a PBI or whatever, I understand.
No, I understand. And again, it was, I mean, the question is, again, whether these words are the right words, what that we're trying to accomplish. I think we've had a more fulsome discussion of it this time, so I'm an idea of what it's trying to do. I'm still not sure that this bill accomplishes it in the best possible way. So with that, is there a motion?
Move to go back over there.
Is there a second?
Second.
All right, it's been moved and second. We take this bill by for the day. Somebody's fair to that motion will say aye. Aye. Those opposed? All right. Thank you, Senator.
Okay, thank you for your consideration.
We'll work on this over the interim. Thank you, Mr. Petto. Senator Craig.
Yes, sir. Thank you. Good afternoon, Mr. Chairman, members of the committee. I bring to you Senate Bill 807. This legislation is amending the Virginia Real Estate Timeshare Act. It offers key benefits for both consumers and timeshare resellers by enhancing privacy protections and reducing liability. By removing the requirement for resellers to retain copies of government-issued photo IDs, the risk of identity theft is minimized. The resellers are relieved of the burden of safeguarding sensitive personal information. This change also ensures compliance with legal restrictions on photocopying certain IDs, such as military identification, and simplifies business operation by reducing unnecessary record keeping.
Thank you, Senator Craig. Senator Craig, I know we've got some folks from Depot here to speak to this.
Yes, I do.
And they were kind enough to come to my office. I will, for the sake of consistency here, say that when this bill was first came to us from the House side, we had some back and forth. We had, I think, a different person from Depot, and we got some answers to some of my questions that I think caused some pause for members of the subcommittee. I think that there was a fundamental misunderstanding. So I think we're looking for an epiphany here, I think, in the words of Senator Evan. Because we were talking about the ID, we thought we were talking about the photo ID of the purchaser of the unit, but I think we've learned in the interim and with the time between the first was that we're talking about something different. So if folks from Depot can come forward, Mr. if you don't mind. So whose photo ID is it that you guys we're talking about keeping here in this bill that we're now going to no longer need to keep?
Yes, good afternoon, Mr. Chair, members of the committee. My name is Steve Kirshner. I'm from DPOR. Again, thanks, Senator Craig, for bringing the bill. In response to the question, the photo ID requirement that's supposed to be kept for 5 years, not saying where it's kept or how it's kept, is for the lead seller. So that would be the employee of the timeshare company who is, in a sense, in like the car sales transaction, it'd be the equivalent of the car salesman's ID that's being kept. There's still other demographic information of the lead seller that is kept. It's just not a copy of the photo ID.
Gotcha. All right. So again, I had asked questions about, I was concerned about seller impersonation fraud and buyer impersonation fraud. This was the idea of the, and I think to be fair to the person who was here to answer, I was so far off of what we were talking about that he was confused by my questions because I was talking about something completely different than what is the subject of the bill. So I'll take the blame for that. But do any members of the subcommittee have questions, understanding now what it is the salesperson's photo ID that we're asking not to keep? Go ahead, Delegate.
Thank you, Mr. Chair. And while I appreciate that is the answer, I think the confusion is more because that's not how I read it when I read it. So I just want to make sure if that's what we're talking about, that's what
Thank you. And
it does.
would you like me to answer? Yes, Mr. Chair. So looking at the text of the bill, if you look at 55.1, 2245A1, It's the name, home address, work address, if different, telephone number, and email address. Then we have that struck-through language regarding the ID of the lead dealer who provided the contact information. So that lead dealer is the employee of the timeshare company who's involved in the selling.
And then follow-up question.
Delegate Coiner.
So is there a reason, if it's someone who's acting in the capacity of their employment, why we are obtaining their home address? I'm just curious if it's through a business nature, why we're collecting someone's home address as well.
So, Mr. Chair, I don't know the intent of the original language when this was put in as far as the breadth of the information that's being put in place. I wasn't here with DPOR when that was put in place, but what I can say is I understand the reasoning behind all the components was to essentially ensure that if there was a question about who was the salesperson, that they would be able to sort of track down that person and find if they had engaged in a bad act, find that person. And what we found is that over 10 years of administering this law, we haven't needed the photo ID. We've never asked for it. It's never come up in any of our disciplinary cases. And we believe that if we have this other information, home address, work address, contact information, that we would adequately be able to find the person in the event we needed to for disciplinary action.
Any further questions?
No, Mr. Chairman.
All right. Go ahead. So, all right, is there anyone in the audience wishing to speak in favor of the bill, come forward. All right, and DPOR, you guys are in favor. Anyone in opposition to the bill? All right, sounds like there may still be a little bit of confusion about the purpose for the bill. I've had my particular question answered. I don't know what that's going to do to the rest of the committee.
Yes,
Again, we do have the unfortunate sort of precedent where we did something different before, so I leave it up to the subcommittee
Yes, sir.
to decide what they want to do.
Chair, move to report.
All right, Delegate Austin moves to report.
Second.
Seconded by Delegate Arnold. Clerk will open the roll. I hadn't heard the ding yet. I'm waiting for the ding. Delegate Delaney's anxiously waiting for me to hurry up through my docket here. It's not me, it's the technology.
So, all right, I'll take the voting system down.
All right. Here I was about to set a record.
It's a good sound. It sounds like you're boarding a plane.
The clerk will close the roll. Bill reports by a vote of 4-3.
Thank you very much. Y'all have a wonderful day.
Yep. If there's no other business to come before us, the final meeting of the Housing Subcommittee for 2025 will rise.